Okay, let's get started. And once again, welcome and thanks for joining today's session, ProbateCash, the solution to the probate liquidity problem, a webinar brought to you by ProbateCash. I'm your host, Molly Driscoll. As a reminder, type your questions in the chat window. Mark will address questions after the presentation. If your question is case-specific and confidential, please indicate that in the chat and someone will respond separately after the presentation. Our presenter today is a professional with extensive experience in the probate field. Marc Harris is an attorney admitted to the Florida Bar in Southern District of Florida. Marc is also a member of the Florida Bar's Real Property Probate and Trust Law section. Marc has been working in the specialty finance industry for over 25 years and involved in the purchasing of over $100 million worth of assets. Most of his purchases, pursuant to various state laws, required court hearings, many of which Marc has either attended or appeared as counsel. As the CEO of ProbateCash, Marc is now spearheading a relatively new industry of purchasing interest in actively pending inheritance claims from estates or trusts. So now without further ado, let's hear from Marc, who is also, by the way, in Florida. So he's been dealing with some weather. So Marc, can you start us off with what ProbateCash does?
Sure. Thanks, everybody. It's good afternoon to everyone. We have a whole bunch of people from around the country joining us. As Molly said, I am a hurricane evacuee today. I'm actually working out of a house. So if you hear a dog bark or some noise, it's a live webinar. That's what you'll hear. Uh, I've spent much of my career, as Molly said, providing liquidity to people who are entitled to cash flows that are due to them in the future. ProbateCash has focused in on one of those cash flows, and that's inheritance. A lot of people who are in probate have no idea about probate. They don't know the process, and all they know is from the movies. They know somebody passes away, they go to a lawyer's office, and they hear the reading of a will, and they get a house or drive away in a sports car or something like that. You guys, of course, know it's very different than that. So what ProbateCash has started to do is when people realize that it's going to take a long time before they're able to obtain their inheritance, and that there's this whole world called probate that they had no idea about before, that's when they contact you guys, and they learn it's going to take a while, and that's when they contact us. And what we do is we'll provide them some of their inheritance today in exchange for them assigning a little larger portion of their inheritance when the assets are finally ready to be distributed from the probate court. So they get some money today, we get paid later on. We file our assignment in the probate court so everybody knows what's going on. But that's pretty much in short what we do. We come in and when anxious heirs need money today, we provide them with some of their money today. They get the rest of their money when the assets are distributed, and some of that money comes to us.
Okay, great. Now, Marc, I know you've done webinars for lawyers and realtors and estate administrators, but for today's webinars, we only invited paralegals from around the country. Why is that?
Sure. So, I'm an attorney, as Molly said, and I know that paralegals are on the front line of just about everything. Paralegals are smarter than most lawyers, certainly smarter than me, and paralegals are in contact with the lawyer's clients, and they're doing the work. So who better to have make sure that they understand the options for beneficiaries of estates or administrators of estates or folks who are waiting for their inheritance. It is important that paralegals also know that ProbateCash exists. It can benefit everybody from you to the beneficiaries, because you're the one who is frustrated receiving calls from anxious heirs who aren't even your clients, contacting you, screaming at you sometimes, when am I going to get my money? And that is, you are left just trying to explain to them, well, this is how probate works. So we got to wait for the claims period. We have to wait for other creditors. We have to wait for the court to schedule a hearing. We need to wait for the house to sell. We need to wait for an auction for other personal assets to sell, right? Right. So you guys have all heard this. That's probably why you're on this call. And we wanted paralegals to know that instead of just being frustrated themselves and having to field those calls, maybe having somebody like ProbateCash offers a practical solution for the liquidity issues that beneficiaries of estates who are waiting for their inheritance have in the real life.
Okay, that makes sense. Now go back to basics for me. How does an advance from Probate Cash work?
Okay, so the basics of probate cash, as I said, somebody contacts us or they contact you and you tell them to contact us. They're looking for money. We will advance them money. First, we take a short application, not very long at all. Just want to know a little bit about the case, want to know where the case is. Um, we take a look at the case. We have underwriters in our office who are familiar with probate. And just like you guys are all paralegals, just like any kind of asset, we want to make sure that our customer, number one, is who they say they are and actually entitled to an inheritance. And number two, what is the inheritance amount likely that they are going to receive? So those are the two threshold questions. We'll probably talk to you as paralegal or to the attorney, somebody in the firm, just to make sure that there are no surprises. We do not believe in surprises. We want everybody to know there's an advance that's going to occur, an assignment of the inheritance, and that's why we file it with the probate court. Nobody should be surprised. Everybody should be on the same page. These are not adversarial. They're not intended to be adversarial. We're just trying to help somebody get through a time when they can't access their inheritance. So we can usually fund the transaction in as soon as 1 to 2 days, as soon as we talk to the beneficiaries. I mean, that's who they say they are. And then we wait. We do follow that's another thing we do actually. We'll follow the probate case as it goes through the courts. So potentially instead of the beneficiaries calling your office all the time saying what's going on, they've actually started to develop a relationship with some of our funding executives in our office. And so we can tell them, here's what's going on in the estate. Here's what we believe based on our experience, how much time it could be. And taking into account that the last thing we want to do is make your firm look like bad guys. So we're always making sure that the probate attorneys are in the best light at all times, understanding that you all are doing what you can do, and a lot of it is outside of your control. So we understand all of that, and that's the nature and spirit of our conversations with beneficiaries, our customers, your clients.
Perfect. Now you mentioned 1 to 2 days. How can Probate Cash fund in advance so quickly?
Okay, so that's a good question for an infomercial like this.
Mhm.
So the reason we can do it so quickly is we're not a lender. These are not loans. These are non-recourse advances, actually. And so what that means, and you guys probably know what that means, but we make an advance. And if we don't get paid because there's not enough assets and the inheritance to pay us back, that's a risk that probate cash assumes. That's on us. So there's no recourse for us against the beneficiary, our customer, if, for instance, a creditor's claim wipes out the inheritance of the estate, or the assets sell, but they sell for far less than we thought, and we're not able to be paid the entire amount. That is non-recourse, and it's us. We do not take collateral like you would see in a loan. So there's no need for a credit check. We're not worried about what the credit report is because these aren't loans. We are advancing against an inheritance that is going to be received. We don't uh, take anybody's jewelry as collateral, anybody's homes as collateral, right? These are just advances against an inheritance. And so, although we do our own underwriting, there's not the same kind of underwriting you would have in a mortgage, in a business loan, a small business loan, those kind of traditional loans you don't see. And so here there are no interest rates, there's no pay time periods where somebody has to continue making payments to us each month or some period of time. These are just straight advances. And because we're not doing that kind of exhaustive credit check that a traditional lender would do, we're able to fund literally sometimes even in the same day. So we are pretty quick. So yeah,
Yeah.
that's another thing. If your firm has administrators who need to save the estate property from going into foreclosure or a tax sale, we've made advances for that purpose. And that, of course, benefits all parties involved and we're able to do that because we're able to get the money to them immediately.
Okay, now who ideally is Probate Cash right for?
Okay, so probate cash is really right for anybody who needs money immediately and probably has no access to traditional lenders or doesn't have the time for traditional lenders, doesn't have family. Yeah, we have fees and our fees are high because they're, as I said, we don't take any collateral. These are non-recourse. We have to be careful, but the folks who really benefit from our services are, number one, of course, our customers. Right? The beneficiary who needs money, didn't understand the probate was going to take so long, wasn't able to budget themselves or unable to budget themselves to wait until the end of probate, which, as we all know, can take many, many months, even if there's no adversarial issues. It's right for the administrator of the estate if they want to. The estate may need to fix up the house for sale to get fair market value. So estate property going to be sold, but it needs $50,000 in it. $50,000 of improvements in a house can usually does turn into a $200,000 realization of additional purchase price of the estate property. That benefits the administrator, it benefits the beneficiaries, benefits anybody who is entitled to an inheritance there. What we don't want is to see these homes sold to cash buyers because everybody's in a panic, and that doesn't benefit anybody. So it's also good for administrators of estate, or for you guys. I mean, the lawyers and the law firms. Okay, I think so. Sorry, this is a live webinar, and the internet can be a little bit spotty. I'm sorry. What were we? That last question,
We were
Molly?
just talking about beneficiaries, and we were
Oh
saying,
yeah. So
like,
so yeah, I'm sorry. Yeah, so if a beneficiary, we're only in contract privity with the beneficiary who is doing business with us. So if there's a shortfall or any problem, we do not look for the other beneficiaries to repay us. So in short, if there are 10 beneficiaries to an estate and 2 beneficiaries want to do business with us, that's fine. It does not affect the other 8 beneficiaries in any way, shape, or form, nor does it affect the probate case. So if the probate case is on track for petition for final distribution, or the creditor's claims before that are gonna be heard, and it doesn't affect any of those hearings. It's a very smooth, transparent process.
okay, now we said we have paralegals on this webinar. So how can ProbateCash help law firms? I know we touched a bit about that.
Yeah, so it's again why we wanted to invite paralegals here, and the lawyers. First and foremost, paralegals, or we know that you're the ones who are frustrated taking these calls. One, from administrators who are your clients, they're the administrators, but they're so frustrated and don't understand the process, no matter how many times you explain it to them. And the beneficiaries who are calling the administrators who don't understand the process fully, so then they start calling you guys. And we're here to take that pressure off. The one thing that I've learned in my career doing business, where we provide upfront money in exchange for assets that are later coming in, and it's been everything from lottery prize cash flows to sports contracts, whatever you can think of, we do. But we find the one thing that truly helps, not surprisingly, is cash. And people, when they're desperate for money, through no fault of their own, or whatever the case may be, a little bit of money takes the pressure off. It changes the personality of people, and it allows them to meet whatever their urgent financial needs are. And that's what we do. Yes, there's a fee at the end, but of course there's always going to be a fee for something like that, and it's very well worth it. So paralegals, it takes the pressure off you. You can focus on your job, and maybe for the first time with beneficiaries and administrators, you can actually offer a practical solution. And if you refer somebody to us, I know you're all paralegals. There's no liability for referring anybody to us. We're not asking you as paralegals or your law firm for any legal representations or warranties. We may call and chat about the case, but we're not relying on anything you say that would have legal liability. And even if you were concerned about something like that, we would offer an indemnity to you. So I'm not at all concerned about anything of that nature. But what we have found is cash helps a lot. And then second, though, your law firm, probably does some kind of marketing, and sometimes in that marketing, you have to turn down a case because somebody doesn't have money to pay you right off right up front as a retainer. And so in that situation, what we can do is advance money even when the case hasn't been filed yet. As long as there's usually an estate property that's going to be sold, we can make an advance to the person applying for the letters and have them authorize us to pay you directly. you, the law firm. So you get your attorney's fees up front if you're in a jurisdiction that allows that, where you're not waiting until the end of the case to get your money, or you don't want to have to carry the case for cash flow purposes.
Okay, now are there any laws that govern inheritance advances?
So there's one law in California. So if there's some California paralegals here, you may already know about that law. And of course, I don't have it written down, but that's why we're always here. But you can easily Google it. It's inheritance assignment statute, and we actually use that statute in all of our transactions that we do. The spirit, if not the letter of the law, in all the other states. Most importantly, none of the states actually prohibit what we do. And so again, we still file the assignment with the court so that all the interested parties, including the judge, are aware of the assignment, and the judge can always be the judge and ask about it. But the judges have seen enough of these, and this is, it's a new business to some, but not a new business to the courts. They've seen enough of these. So our company has advanced now over $100 million in advances.
Wow. Wow. And thanks, Mark. So I guess we're already past that 15-minute mark. And as promised, you're going to stay on to answer some questions. But if you need to leave now, we're going to send everyone a link to the recording of the presentation and the question and answers. So let's get to everyone's questions. Okay, the first one is, can multiple beneficiaries get an advance from ProbateCash?
Yes, they can, and often do. So often when one beneficiary finds our company, they take an advance and they're excited, and they'll tell other beneficiaries who are in their same boat waiting for their probate, hey, you can get it in advance as well. And even better news, if those other beneficiaries need advances, often we can make those advances same day because we've already done the underwriting and due diligence on the court file.
Okay, now what information do you need from my firm to advance the transaction?
All right. So we may call you. We have underwriters. As I said, we're going to look at the case number. Presumably, we will have that case number even from the beneficiary. We may ask you and just probably say, do you expect, yeah, we really don't need anything from you. We have the documents there. If there's a question in our underwriting, we may ask it. Do you expect any big claims to come out for creditors? Anything like Medicare that could really wipe out the inheritance. We may ask you that question, and anything else that you may be aware of that we wouldn't be aware of from the filing. We want to know how we're going to get paid back, because usually the administrator pays us back when the estate assets are completed, but sometimes you, the attorney, may be holding the funds, or your law firm will be holding the funds, and so we'll ask to be paid out of the IOTA account.
Okay, great. It looks like we have a couple questions more in the Q&A, and I want to, some of them are longer, so if you want to read them too, Mark, as I read them out loud. The first one are the stipulations for when probate does not follow the normal course of business, but still results in a beneficiary receiving funds. So they say, for example, if a settlement agreement is reached as a resolution, would the client just need to contemplate the advance when coming to any such agreement, or pay you back out of their proceeds, despite them not being received as expected?
So let's see, are there stipulations? Let me make sure I understand this. So when probate is not for
Mhm.
business, so if a settlement agreement is reached as resolution, are we talking, I guess, about if there is an adversarial situation in the probate case? That may be so I did not discuss it, but we will get involved in adversarial cases. So if that's what this is about, if there's a challenge to a will, or some other issue about the assets, we'll still make advances. And then if there is a settlement from that, that would be taken as basically as if it was their portion of the inheritance, and we would be expected to be, we'd want to be paid back out of the settlement proceeds directly. Would be the way that we have to get paid back. So we wouldn't want the money going to the beneficiary and then if the beneficiary pays us, or the person there. If that's not the question, definitely feel free to email me separately, and Molly will give it. My email is Marc, MARC, at probatecash.com. You can also call me on my phone, 561-476-0018.
Great. Now the other question is this accessible? Is this is accessible nationwide? So do clients out of state where probate is being processed need to know if anything, if interested in this service? So I think it's talking about nationwide
Yeah,
availability.
so if there's, first of all, we do business throughout the country. Second, there is oftentimes where there's a probate, for instance, in California, beneficiaries live in Nebraska, wherever they may live. That is not a problem at all. We do the transaction. We still file the assignment of the inheritance where the probate case is filed. But there's nothing else special about it. So we can do business with any beneficiary. They can even live out of the country. As long as they're a beneficiary of an estate, they're expected to receive an inheritance.
And finally, they ask during the timeline, if the probate takes 5 years, would there be any consequences to the individual who took the advance?
No, not as long as so no, but it
Mhm.
depends if the delay was caused by the beneficiary. So we will make sure in our contracts that the beneficiaries cannot delay the process. They can't frustrate our ability to get paid back. But we understand that sometimes litigation will occur. Sometimes the probate does take 5 years. And so I also see that there is another question, which I was waiting for. I meant to actually address it. The important question is, what are our fees? And
Mhm.
so it kind of ties in with what happens if it takes 5 years. Um, our fees are as high as 25% of the advance amount every 90 days, and we cap them though at 100%. So if the fee gets to 100%, that'd be like a year. But if it goes to 5 years, that fee still stays the same. So therefore there would be no consequences to the beneficiary if probate took 5 years. So hopefully we know that going in, because we may adjust pricing or make different determinations, because that is important. But by all means, we certainly have advances that have been outstanding for about that long through nobody's fault. You had COVID, you have busy jurisdictions anyway. So that does happen.
Perfect. I think you did get that fee question, so I think we got everyone's questions. But if you're like me and you think of something after the call, we will be sending out a follow-up email with the link to this webinar. And also, please follow us on our LinkedIn page because we've all updated information and even the other webinars posted. Again, if you think of other questions offline, you can call Mark at 561-476-0018 or email him at Mark, and that's MARC at probatecash.com. And thank you so much for attending today. I'm sorry for all the technical difficulties. As Mark says, we're in hurricane and home internet, but thank you for your patience and have a great day.
Take care.